July 18th, 2012 is Justice Dunder Cheap at the Justice Building. At the Justice Building is almost ironic because I'm not sure if justice is to be had here. Black's Law Dictionary defines justice as fair application of laws. How are you doing today?
Doing good, thank you.
And what's your name?
Sally Brooks.
Would you like to be interviewed?
Yes, I would.
So you saw a hearing today.
Yes, I did.
Are you witness to hearing? And the hearing is regarding myself. And what do you think about the hearing that happened today?
I think the hearing that happened today was completely about the court refusing to listen or hear anything, and the purpose of a hearing is actually to hear what a party has to say.
Yes.
So what we saw was the judge basically saying, no, I can't hear you. Lots of valid points were presented, questioning just the validity of the whole thing that was before the court, and the judge wasn't interested at all.
The first point that was made today that I raised to the court was yesterday I appeared because I was forced under protest and duress to sign a promise to appear, to plead to a charge regarding failure to appear. Now when I appeared yesterday, there was the big question mark. No one knew what I was talking about, and they wouldn't actually answer any of my questions. I went down to the Provincial Court office. They couldn't find any of these anything to do with an information regarding a promise regarding failure to appear. And then today I made a direct statement to the court that I want this matter to be struck from the record, or the court's assurances that this will never be brought up again. What do you think? What's your response to what the court said in response to that?
My take on it is that I think the court knows they screwed up, because the day you failed to appear, you actually called the courtroom that very morning and you said your papers and everything are in disarray, you were evicted, you didn't have the date memorized. When is it? And they said you just missed it by an hour and a half. So first of all, you called the court administration, the court was still in session, it was only 11 something in the morning, and the judge was still available. They told you to go to court for the afternoon session, you did, you turned up and you were arrested.
Yes.
For having failed to appear that morning. Then you were made to sign a promise to appear. So I think they want those charges to go away, because you obviously have a witness that you called the court in the morning. You didn't commit a crime because you just forgot what date it was. And third of all, they arrested you for failure to appear in court on the 19th of June, and they actually arrested you in court on the 19th of June. So that proves you actually were in the court.
In the courthouse.
In the courthouse.
Yes.
And you were prevented from going before the judge by the police officer.
Yes, they actually refused to allow me to see a judge that day.
So basically I think they wanted to just shuffle that charge out of the way, because they know they were completely unreasonable. You did not commit a crime, you should not have been charged with anything, and I think they just want to make it go away.
What was interesting is when I pressed the matter, the judge did not want to address it directly, and the Crown prosecutor was that Hilary Drain. She denied that the failure to appear was the reason for the scheduled hearing yesterday, and then I pulled out the actual promise to appear, and I said, if anyone can read, you can see July 17, 9:30 a.m. Here we go. I know what I'm talking about. Please address this. And then only after then that did the judge state, and I thought I redirected the question twice because it was a kind of an evasive answer. I said specifically, I don't want this charge to rear its ugly head at some time in the future. So let's just deal with this right now. I was ready to proceed. The Crown was not. I want this matter dismissed immediately, or the Crown to consent to a withdrawal of the charges. And what did the judge say?
The judge said, Mr. Murray, I have nothing before me in respect of that matter, therefore there is no charge. And that's all I'm going to say about it. So she basically, are we to now assume then that it was an arbitrary arrest? She did arbitrarily and wrongly sign an arrest warrant that she should not have.
Two of them.
Two of them.
Yes.
She also did not fill out the arrest form properly. She did not write the actual charge that you were arrested for the failure to appear.
Yes.
She did not initial it, which is required to do under the Criminal Code of Canada.
Yes.
So she just wanted that to go away.
Yes.
and she did not satisfactorily answer your questions, but at least you got it on the record that there is no charge in connection with that in the file.
And I had my objections noted to
Yes.
all of that
Yes.
several times, and she actually became quite irate that I kept noting my objections, and I think she said, okay, enough's enough with the objections.
She said, I think the court has already noted your objections. She got very, how should we say, frosty. She was a little unsettled.
Yes, it's unfortunate that they get so unsettled when one has the right to note an objection on the record,
Yes.
and that's what the Court of Appeal is looking for later, is was there an objection noted? An objection should not be an offensive thing, it's just a formal notice to the judge that a party is objecting, not agreeing. Do not believe there's any consent going on. Please note, I do not agree with what you're saying, and that's it.
Well, I've seen a lot of the provincial court judges from New Brunswick in action now, and they get very agitated when they know they're in the wrong.
Yes.
And when they know they're diverging from their ethical and legal duty. They get very upset, and they get very rude, and they get very loud.
As an example, yesterday there was a point where the judge would not look me in the eye. There was lots of paper shuffling going on. Do you remember what that was about?
I can't remember.
I can't remember either, but I remember that very distinct.
Yes, it was. It's because when you appeared yesterday, it was for the two charges that were scheduled for today. They changed it on the docket. So instead, you were there to appear for the failure to appear in court, which
Yes.
is what you were instructed to do in the promise to appear. And all the paper shuffling was them all saying, well, I can't find that, that's not on here, and there's no information laid for that, and they just screwed up all the dates. I actually think they did that on purpose because they wanted you to turn up yesterday unprepared.
And then plead everything.
Yeah.
Because that's what they tried to do. They tried to get me to plead everything, even though it was on the docket for today.
Yes.
All right, and then the next thing that happened was I tried to have the court address the matter of the application, because what was filed was an application for to vary an undertaking and to basically have the charges dismissed or stayed. Would you like to talk about that?
Yes, the matter was raised, and the Crown prosecutor, Hilary Drain, stood up and said, I want to object to this because there isn't even a date for a hearing of this application, so how can we deal with this? Well, of course there's no date, because the court is obligated to provide a date, and the court basically said, we're not going to hear your application for dismissal of these matters on the grounds that there is no merit or validity to them. We're going to make you go to trial. We won't hear anything before trial. That's how this court works. And actually that's wrong, because the rules of provincial court practice clearly allow a judge can order a pre-trial settlement conference to resolve issues,
yes,
go over such matters. A judge has a discretion to order all sorts of ways to render justice in a timely and cost-effective manner, but she refused. She said, you're going to trial, and I don't care if you think you're innocent.
Yes, to me that's a charter violation, and it's a misuse and abuse of judicial resources and Crown prosecution services.
Yes, and it's the judge admitting that basically this was Andre's hearing, but she was refusing to hear anything.
Yes.
And to me that is what has to change now. They're just refusing to hear or see anything that could clear these matters up quickly.
What's amazing is that to hear the application would mean a dismissal of all those charges if I was successful on it, and I would have the opportunity to be successful. Yeah. Then there'd be no need to move forward with a trial and tie up all the judicial resources, the Crown prosecutors and all that public funds to prosecute this matter that could be easily resolved by basically looking at the circumstances.
Yes.
And they seem to not want to do that, which is, to me, contrary to their stated goals as an organization and to what the public perceives as what is going on in the courts.
Yes, and what that judge also had the duty to do, not discretion, the power and the duty that would also have resolved everything, was to order under Section 810 of the Criminal Code of Canada a show cause hearing to validate whether there was a necessity for an undertaking in respect of the alleged charges. If there's no validity or merit to the application for an undertaking, then therefore there are no charges. She had a duty to schedule that hearing, and she glossed right over that, and she didn't do it.
Yes.
They're looking for ways to just drive people to trial, and once you're at trial, you will be found guilty. That's what Fredericton City is all about.
And then there's a third matter at today's hearing, which is kind of interesting, because I asked today to just bury the undertaking because there was a specific clause of the latest undertaking that they had me sign, which I believe I should not have to be held accountable to, and that's to keep the peace and be of good behavior. And now it sounds kind of innocuous to hear that, because most people want to keep the peace and be of good behavior, and if it was written in plain English, I'd have no problem with that. But when looking into it, I found out that keeping the peace means if I ever breach the peace, which means causing a riot or a rowdy event whatsoever, I'm in breach of my undertaking, which is a criminal charge that could be up to 2 years in prison time. And then the other thing is that to be of good behavior means not to be a good behavior is to not breach any federal statute, provincial statute, or city bylaw, or municipal bylaw. And with my long-standing history with the city of Fredericton, and the fact that the Fredericton Police Force have targeted me for arrest for matters that other people would just be let go or just left alone, I believe that I'm put in an exceptionally perilous position where at any time the police now have probable cause to arrest me for anything, even as minor an infraction as jaywalking. I could face a 2-year jail term and be remanded to St. John Penitentiary, I'm not sure the exact name of it, until a judge decides to release me. This is unbelievable, and I expressed that to the court very clearly.
Yes, you did.
And I also stated the fact that the connection between the bylaw matters are that the Constable David Beck, the officer, the Fredericton City Police Force officer who arrested me originally for the riding on the sidewalk with a bicycle bylaw infraction, was the same officer who I was serving court documents on the day I was illegally arrested for assault by one of his co-workers there, Constable Stephen Hill. Now that day they had no grounds to arrest me. They could not arrest me, yet they did. They caused me to sign an undertaking under protest and duress, and then the court went along and had me sign a judicial undertaking, which again was improperly conducted. And then when that same constable, David Beck, decided to pursue the matter further, he was the reason why the Fredericton Police Force arrested me again for breach of an undertaking. This one individual is following me along and making sure to cause me issues, and now I could be arrested anytime for jaywalking.
Yes.
And especially with the motivation of the city to just give me a hard time, seeing as how I'm suing them for all the times they've breached my charter rights before. They're motivated to cause that to happen.
I agree, and what concerns me greatly is it's bad enough what's been done to you with all of that, but I'm seeing that this is a regular practice, very regular practice for the Fredericton City Police and courts here, sucking people into a charge on something they didn't do, forcing them to sign an undertaking under threat of going to prison long term. So basically they sign the undertaking just to keep out of jail, which is unlawful and a charter violation. And once they're sucked into the undertaking, the police then just create a crime. Oh, you stepped off the sidewalk into the street, jaywalking, going to arrest you, breach of undertaking, and yes, you can go to jail for 2 years. They're filling the courts with this garbage. It's not even, it leaves me speechless. But I'm seeing certain individuals picked on again and again and again. We all know Charles Blanc, the blogger, the same thing. They tried to suck him into an undertaking that was totally unreasonable and unacceptable. And this is happening all the time.
Yes.
It's a disgrace.
It is, and I noted my objection several times on the record today, and I couldn't believe that the court would not grant that amendment to the undertaking, which, after expressing my position the way I did, which is, this is unreasonable.
Yes. Well, the trouble is, this court operates under the complete antithesis of the requirement of the Charter, which is you are guilty until proven probably guilty, regardless of whether you are or not.
Yes.
So that's why she denied you. It makes them feel as though they've branded you as a criminal. They have to have this undertaking enforced in every little detail, but it's basically saying you're guilty. And she was in the wrong, because the minute she was asked to make you sign an undertaking before her, she should have offered you a show cause hearing with the complainant in front of her and you in front of her to validate whether there was any necessity, and she was negligent because she did not do that.
Yes.
And 2 months later she still hasn't done it, or a month later she still hasn't done it.
On a final note, what I keep hearing from people that I talk to in the court halls of the courtroom, is that they get drawn in on some minor thing, and then the breach of the undertaking start, where they might have 5 breaches of an undertaking. Each breach is itself a criminal offense. It could be up to 2 years in jail, depending if they want to go indictable or summary. And what's amazing is that might end, at the end of it, they might have 10 criminal charges, and most of it is breaches of undertakings that are minor things, and the pressure is on them by the Crown to just plead guilty to the original offense, which they did not do, but will drop 6 of the 8 breaches, and then they'll just say, okay, we'll either do probation or sign another undertaking, or you'll do 6 months in jail rather than waiting out to see the end of the trial and maybe getting 12 years in jail consecutively. I mean, this is unbelievable.
And I think there is a huge agenda to give government statistics for their employees.
Yes.
The probation officers are so busy. We need every one of them. Look how busy they are. Look at all the caseloads. Look at all these criminals we got. The Crown prosecutor, they're so busy every day with all these cases. The courts are so full. But when you look at it, it's all garbage. The courtroom should be pretty much empty, except for a couple of lawyers I know, and police officers, and politicians.
Yes, and also just in a final note, that the plea bargain thing, most of the plea bargains that the Crown engage in are actually contrary to the Crown Prosecutor's Manual. They're not supposed to actually do that.
No, they're not. They're not. It's unethical, it's unlawful.
They're asking people to lie, and then lie on the record, stating that they are guilty of something they've never done, in the hopes that they'll get a lesser of 2 evils fine or jail term.
Crown prosecutors have to be members of the Law Society of New Brunswick and the Canadian Bar Association. Same as legal aid lawyers and duty counsel. Judges were members of the Law Society before they were appointed. How they are operating here is diametrically opposed to everything they should stand for and are legislated to do.
Yes.
And we just have to keep telling the public, hey, don't feel picked on, this is happening every day, but it's got to change. And publicising it is the way to go forward.
Alright, thank you for that, Sally.
My pleasure.
Have a great day.
And you.
This is Justice Done Dirt Cheap, July 18, at the Justice Building, Fredericton, New Brunswick, Canada. Thanks for watching.